knock off in an hour. My slides are actually a bit longer. I've done slides because firstly we need to know if people are okay with this being recorded, because it will go up on the Ngā Toki Whakarururanga website. And there's two parts to what I want to cover. And we'll stop after the first bit and then see how we're going for getting the rest of it done, or we might need to do a second one. Okay, let me share screen and, oh, why is it doing that? So this is very much a 101. Some of it will be familiar to some of you. As with the digital one we did last night, I'm happy to go through more technical stuff with those who want to do the technical stuff. But this is really to give you a sense of the issues that are happening in what we would call the broad trade and investment space. So, whoopsie, starting off even in the wrong. I wanted to ground us first in some of the Y262 extracts that we try to raise when we're dealing with the negotiators who really don't get this kaupapa. Just how fundamental relationships to Te Taiao are. So these are just a handful of quotes. Relationships are so crucial to Māori culture and identity that their survival cannot be separated from the survival of the culture itself. In many parts of the country, the environment that created Te Ao Māori has disappeared. Some matters are of such central importance to Māori that it is appropriate, in light of the treaty relationship, to move only with Māori acquiescence or consent. And it is possible to contemplate circumstances in which it may be necessary to place the Māori voice as the New Zealand voice in the international arena. Now, that's not what happens. When we are dealing with the world of trade and investment agreements, they fundamentally trump Te Tiriti o Waitangi. Free trade and investment rules say what governments can't do to protect Te Taiao and to counter the climate crisis, because those actions affect commercial interests that are advanced and protected by the trade and investment agreements. And I'm going to talk about two different kinds. Firstly, the free trade agreements, which are barely about what we call trade. They cover all sorts of things these days, but they're agreements that have teeth and they're enforceable by states. So the rules in those agreements can override Te Tiriti o Waitangi, override the UN Declaration, override unenforceable environment and climate treaties. Then there's another set of agreements known as investment agreements that provide special protections for foreign investors and allow those foreign companies to sue governments for mega damages if environment and climate policies adversely affect their value or their profits. And so this is an arena that operates supranationally, but has fundamental impacts on what can happen within Aotearoa and for Indigenous peoples anywhere else. So I want to focus first on investment agreements because they are the biggest threat to any effective actions in the climate and environment space. So sometimes there are separate investment agreements. New Zealand governments have not generally entered into those, but free trade agreements often have investment chapters that carry the same rules and rights for foreign investors and ability to enforce them. So they give special protection to foreign investors against regulations, court decisions, a whole range of other state-like activities that negatively affect the value or profits of those investors. So, for example, tightening rules on foreign investors, such as requiring foreign investors as part of a vetting process to conduct a Te Taiao Waitangi assessment or to secure mana whenua consent to their investment. Another might be if there are investment or other laws that are changed contrary to the expectations of the investor when they invested, such as changing the rules on offshore or onshore mining. If there are moves by councils or resource decision-making bodies to terminate or even not to issue or renew permits and licenses, for example, in relation to water bottling and irrigation, or even if there are domestic court decisions that go against the investor that they say breaches their investment protections, such as if, Mike, you'd won your climate case. And the thing that's really pernicious, really deeply problematic about these investment chapters is that they give the investor the right to enforce those rules directly against the government in what we call investor-state dispute settlement. So foreign investors who are covered by an agreement with the Crown, entered into by the Crown, can enforce these special protections directly against the government in offshore tribunals, not in the domestic courts, and tribunals that are notoriously pro-corporate. If we look, for example, at climate policies, this allows foreign corporations covered by one of these agreements to sue the New Zealand government over climate policies, seeking billions of dollars in compensation. And I'll give you an example shortly to show I'm not exaggerating. So the first of the problems with this is that the rules are explicitly designed to provide protections for investors. So they are pro-investor rules. There is no counter liability for the harms that those investors cause. That's outside the scope of the agreements. And what we're finding is that investors are encouraged to bring these disputes about potential breaches of these rules because there is third-party funding that's being made available by specialist funders, which encourages foreign investors to speculate on bringing these disputes because it's not going to cost them anything, and the third-party funder gets a share of the spoils. A second element of these investment disputes is that the judges are not even like the crusty old judges in our domestic courts. The judges on these offshore tribunals are themselves investment lawyers, often who act for investors, academics, others with no conflict of interest rules. And they're often known as the ISDS mafia. And so there is no pretense here about an independent judicial process. Thirdly, the tribunals that hear these disputes are ad hoc. They're set up for one investment dispute or another investment dispute. The rules are vaguely worded. The pro-investor rules are vaguely worded. Because they're ad hoc tribunals, there's no precedent. which means you've got inconsistent interpretations, no appeals on the merits of the decisions, which has a consequence that governments don't know and get very risk averse about what the outcome of a threatened case may be. Worse than that, the whole process can be held in secret. So the documents, the hearing, the existence of the case itself can all be kept secret from the people in the country that is being sued. And even though they would end up having to pay the costs at the end, all of this can remain in secret, including the outcome of the case. There are no rights for affected communities who may have been behind the decisions to cancel a mining permit or behind certain climate policies, and certainly not for Indigenous peoples who are affected by these decisions to participate in the process. And even if there is what we call amicus curiae briefs, then they are at the discretion of the panel of judges and only within the boundaries of what they might allow if they allow them. And finally, at the end of this process, the damages awards that can be made are not only what the investor has invested, but they cover the future projected profits of the foreign investor, subject to compound interest, and sometimes to punitive damages for the actions of the government in relation to the investor. Now, there's a heap of examples I could give you, but one of the first things I wanted to say was that there are big law firms who make a lot of money out of ambulance chasing, increasingly around the area of climate. So this was a quote from last year from one of the big law firms, Jones Day, in its corporate newsletter. Climate change litigation is an opportunity for companies exposed to certain climate-related government measures to vindicate their rights. These investment treaties may be in conflict. These climate treaties may be in conflict with measures taken. Put it the other way around, get it right, Jane. The investment treaties may be in conflict with measures taken to satisfy states' new climate-related international obligations. The treaties were made well before the climate issues were on the table, but they remain in force. There are currently at least 13 pending climate change-related disputes brought by investors against states in these ISDS tribunals. And what the law firm suggests is that companies in the industries most affected, such as fossil fuels and mining, should look at their corporate structures to restructure so that they can locate in countries that can take advantage of these investment agreements before any dispute arises. And it's important for those companies to assess which of these international investment treaties will best protect their company from any adverse climate-related government measures. Now, there's lots of examples of cases, and I just pulled this chart out of a recent survey of investor-state dispute settlement cases over the 20 years from 2000 to 2020 affecting Indigenous peoples. And virtually all of them relate to the environment. And they include US, Canada, Zimbabwe, Venezuela, El Salvador, Ecuador, Peru, Ecuador again, Panama, and Bolivia. So this is not new. What is new is the potential bonanza that climate policies are presenting to foreign investors to bring these disputes. So there's an international UN agency called UNCTAD that has been pushing for the termination of these agreements, and they publish a report periodically. What they have said in a recent report is the urgency of climate action adds to the need to reform these investor-state disputes. Many past cases relate to sectors of direct relevance to climate action. Investor claimants have brought at least 175 ISDS cases relating to measures taken for protection of the environment. Investors in fossil fuels have been frequent ISDS claimants, initiating at least 192 cases. And the last decade has seen the emergence and proliferation of such cases brought by investors in the renewable energy sector. So 20% of known ISDS cases have involved fossil fuels disputes, with an average award for those that have won of around $600 million. Just a very recent example, some of you will know the lovely Clive Palmer, Australian mining magnate, who is a great fan of these agreements. He has been suing, he's got numerous cases going at present, suing the Western Australian government over legislation that indemnified West Australia in a dispute relating to mining. And he lost in all of the Australian domestic courts. So he reincorporated his company in Singapore and has launched an ISDS dispute suing Australia, and he is an Australian. It's what we call boomerang cases, using an investment chapter in a free trade agreement between Australia, New Zealand, and the 10 ASEAN countries, which include Singapore. New Zealand is also a party to that ASEAN Australia New Zealand FTA and has ISDS obligations under it to all of them except Australia. Palmer is claiming 300 billion Australian dollars, including $10 billion in moral damages for Australia's action. And that dispute was not publicly announced in Australia. It was found by people looking at what was seen as a liability in the government budget books. So New Zealand has ISDS in 8 free trade agreements covering some of the major foreign investors in Aotearoa. The China Free Trade Agreement, the agreement with South Korea, agreements with Singapore and Thailand, although both of those, the government would have to consent to the dispute being brought, with Malaysia, with Taiwan, under the TPPA and its successor once the US left, it has ISDS with Canada, with Japan, with Mexico, and with Singapore, subject to the consent. And then in the ASEAN, Australia, New Zealand one that Clive Palmer is using, it has ISDS with Brunei, Cambodia, Indonesia, Malaysia, Burma, Laos, Philippines, Thailand, Vietnam, Singapore with consent, but not Australia. So all of this is horrifying, and those of you who who were aware of it during the TPPA campaign will know that that had a really significant impact. And as a consequence, it's one of the few things that Winston got right in the coalition talks between New Zealand First and Labour back in the 2017 election. It was agreed that there would be a policy of no ISDS in future FTAs. And they have actually stuck to that, but that is still just a policy. It can get changed, including by an incoming government or by a government that can't get agreement from the other party in a deal it really wants. And it's not being applied in reviews of existing agreements such as the CPTPP. So there are big risks of ISDS disputes for Te Taiao and climate crisis policies in Aotearoa, and what we call a chilling effect if there are threats to bring such a dispute. For example, post-Gabriel changes to forestry practices and remedial obligations that might be demanded of forestry investors, bans on offshore and onshore mining or fracking, fossil fuel phase-outs, caps on agricultural emissions, restrictions on taking water, denial of permits for wind farms, changes to ETS, although interesting that, of course, Māori who might be affected by changes to ETS wouldn't be able to bring an ISDS dispute because it's only available to foreign companies. Introduction of requirements for iwi consent, or of iwi who are authorised under laws to make or withhold consent if they withhold consent. Finally, in the investment agreements, there are no effective Treaty o Waitangi protections. The Treaty o Waitangi exception is only for more favourable treatment for Māori, not for laws, policies and decisions made to comply with Te Tiriti o Waitangi. There are a few other protections that apply, and if the government tried to rely on them, they would be decided by the ISDS mafia in the investment dispute panels. Y2522 Tribunal on the TPPA proposed that there should be a protocol developed by MFAT if there was an ISDS dispute involving Te Tiriti, but despite efforts in trying to push them, what MFAT put up and the Cabinet agreed to leaves all the power over this with the Crown, and it's only in a dispute. Even without ISDS, the other state parties can also still enforce investment rules against Aotearoa, New Zealand, and the US is currently doing that with Mexico under an agreement that they have there. So that is the happy story about ISDS. So questions, comments?
He Pātai Jane. Just in terms of the ISD cases that you shared, but also those that have come and gone, what proportion have found in favour of the claimant versus the Indigenous peoples that were in the position where they had to respond?
Well, of course, it's not the Indigenous peoples who respond; it's the state that responds, and they don't have a voice.
Sorry, the Indigenous peoples that were impacted, by the state to be the recipient or the respondent.
The majority of cases have been won. By the investor. I can put for you a link to the latest analyses from UNCTAD on that were in that document that I presented. Sometimes what we find in those disputes is that there is a settlement because states are really nervous about what the potential outcomes will be. And so there ends up being either a mediation or a settlement, and those settlements aren't disclosed usually. So it's very hard to work out what the actual amounts of those settlements are. But one of the biggest things, and this was an argument that the Waitangi Tribunal had considerable sympathy for in the initial inquiry in 2522, is what's known as the chilling effect. So if you think back to what happened with Philip Morris and the plain packaging tobacco, that was a classic example of the chilling effect of cases brought in Uruguay or in Australia against other countries, including New Zealand, who were thinking of introducing those policies. And that doesn't factor into any of the kind of stats you have in the actual disputes. And it's very hard to figure them out. One of the things I'll refer to in terms of the environment chapters is also that in the recent agreements, there is a guaranteed right of foreign states and foreign investors in the name of transparency to have rights of prior comment on the introduction of new laws and policies, and potentially encouraged to be given rights to comment on potential decisions that might adversely affect their investment interests, and an obligation on the part of the state to take those into account and to explain the basis of the decisions. And in the most recent ones, for the investor to be able to proactively raise measures that they say are unnecessarily burdensome or are unfair or are out of date or whatever, or are not supported by evidence, to have a review of those measures. So it's the data is kind of a subset of those bigger pictures.
Kia ora, Jane. Tania Te Whenua here with a question. I was wondering, in terms of the remedies, so we've noted that governments can be sued. Is there any other remedy? For example, can the decision maker force our government to review policy?
Yes. One of the certainly when you're looking at settlements, the settlements generally involve withdrawing the measure that is being objected to. The penalties, in some cases, the penalties will take account of whether the state has said it will review the measure. If it said that it won't review the measure, then you're most likely to have the most extensive awards and compound interest. I mean, one of the ones that became most infamous was involving Ecuador and the pollution of the Amazon, and there was a court decision there, and it was the court decision that was being challenged, and so the government was basically being required to breach the separation of powers and the constitutional provisions to override the court decision, and that ended up being a very long problematic dispute. So yes, there are various ways that, especially if government's budgets can't afford, what is it that Clive Palmer is claiming, $600 billion, then governments are required to change the measure.
Wow. And just for clarity, could that occur without any public knowledge? We might not even know about the case or the decision.
Yes. So you'll see most of the stats refer to the number of known disputes and decisions. Now, in the more recent New Zealand agreements, there is some provision for disclosure, but not disclosure of all the documentation and so on. And that's what makes it really difficult to be able to engage with the arguments. And it assumes, and this was an issue that we had with the ISDS protocol with MFAT, it assumes that the Crown or the government in a dispute actually has the competencies to be able to, and the will, to be able to make the arguments. And that's been an issue. And, you know, I in case all of this sounds extreme, there is, even now, the EU is withdrawing from one of these agreements that most of the climate disputes are brought under, called the Energy Charter Agreement, which was specifically designed to protect the interests of energy transnationals. And the number of disputes and the amount of the awards that are being made there are so horrendous that even the EU, which has investment interests, is withdrawing from that agreement.
Thank you. And can I ask a follow-on question? What's the relationship between any exceptions that might be in favour of the Treaty of Waitangi or Indigenous peoples and the ISDS ability of investors to take these disputes? Are they effective, these carve-outs, or?
No, and as I said with the slide, there are a series of problems with this, and if you're interested, have a look at the arguments that were canvassed in the initial Y2522 inquiry, because the treaty exception refers to the right of the government to give more favourable treatment to Māori in relation to Treaty of Waitangi obligations that the Crown sees, but is subject to what we call the chapeau, or that it's not arbitrary or unjustified discrimination or a disguised restriction on investment. Now, there are several problems with that. The first is not implementing, for example, if you adopt a ban on fracking, at least in part as a treaty compliance with a treaty obligation, that is not giving more favourable treatment to Māori. More favourable treatment to Māori is something like positive discrimination. So, you know, special preferences for government procurement projects or whatever. In addition, the ability of the dispute tribunals to examine whether something is necessary to implement the Crown's obligations, that's not able to be challenged in a state-state dispute. But because of the historic nature of this exception, it doesn't exclude it being challenged in an investor-state dispute. So an investment panel could firstly look at whether this was more favourable treatment. Secondly, whether it fell under this chapeau of arbitrary or unjustifiable discrimination or a disguised restriction on investment. And thirdly, it could look at whether, in fact, this was a necessary action to implement the Crown's obligations in the Treaty of Waitangi. And we have been trying to get that dealt with, and the Crown is stuck in the 2001 exception and refusing to change it. Mike.
Thanks, Jane. Well, you're starting to touch on the question I wanted to raise, but I'm conscious that we're rapidly running out of time. But so what's the strategy for rolling some of this stuff back?
So one of the good things is that the campaigns against ISDS have been successful in recent times, for example, to the point where they weren't included in the UK FTA, in the EU FTA. But there is a review of the TPPA, CPTPP happening, likelihood of getting other carve-outs, other agreements there, side letters there to say we won't use ISDS are pretty minimal. Certainly getting it out of the agreement ain't going to happen. Some of the other agreements like this ASEAN, Australia, New Zealand one's just been refreshed. And I would invite you to have a look at what the outcome of that is on ISDS. So there needs to be a campaign on it. And it needs to be a campaign to actually make this a law, not just a policy. Ironically, New Zealand First had a, what did they call it? Something like Fighting Foreign Investment Corporate Power Bill or something, that would have prohibited ISDS in future agreements. Getting a petition that requires a hearing that then puts this up is another step, but education is the first step. So this will be part of the Boren Foundation has created a grant for Ngā Toki Whakarururanga to do work on Te Taiao and climate, and that will include, in part, ISDS, and developing a range of resources from populist resources to more detailed resources to be able to educate, not advocate, but educate around this. I did a submission personally on the offshore mining environment committee inquiry recently about ISDS. So you're on mute, Mike. You're still on mute.
Sorry, Jane, I was just answering a phone call. Oh,
okay.
Yeah, no, thanks for that response. And so, have you committed that strategy to paper at all?
This is kind of a first step to get a critical mass together to work out what are the most effective strategies. Yeah. I mean, there was, as you'll recall, during TPPA, there was a real groundswell of understanding. And I was just at a hui recently with someone on Mātike Mai, and we were talking a bit about this, and I referred to kangaroo courts. He says, oh, yeah, I remember that now. Yeah. So, but Billy Joe had her hand up as well.
Oh, thanks. Oh, kia ora, Mike. Thanks, Jane. Is an ISDS time locked? Can it be historical?
It has to be within firstly, it has to be within it varies across agreements. It usually has to be within the time frame after the agreement came into force. Right? So some of them date back, the one with Singapore dates back to 2001, for example. It relates to investors or investments that predate that, but not to things that are done after that. Some agreements, however, have some specific time frames where you have to have given notification, done consultations, etc. So that's one of the technical problems of actually sitting down and mapping the withdrawal of these from these.
I'm only thinking about it in the sense of, can we use this ISDS mechanism for he whakaputanga?
Not unless, no. No. Not unless because it's the New Zealand government that would need to take action against another country's investor under one of these agreements?
No, we would essentially be the investor suing the Crown in Britain.
There is no such agreement with Britain.
But there was an acknowledgement of he whakaputanga by the king.
Yes, there was. And that is, these are, if you think of these, I mean, it's a great question, Billy Joe, but if you think of these things as if they're a code and they create the entire universe, each agreement creates the entire universe of what you're allowed to do. So to bring a dispute under he whakaputanga, you would not have any international investment tribunal process you could identify to do it under.
Why?
Because there isn't an investment treaty that creates that legal forum.
But you just said that you can do it behind closed doors.
Yes, but only if you are allowed by the investment agreement to bring a dispute. And the investment agreement says you can keep that dispute secret, but you can only bring the dispute if the agreement allows you to.
Oh, right. Yeah. So they're writing the rules. Yeah, I can see. It's the law. It's done it to us over and over again.
But the other thing that the Boren Foundation has agreed to fund is a project on constitutional transformation of the international treaty-making process in the trade and investment area, right? Which is, how does Mātike Mai, how does he whakaputanga, how does tino rangatiratanga and te tiriti, what does international treaty making look like in that space?
Yes.
That's somewhere where that question can be explored.
Okay, good. Okay. Thanks.
Now, I'm aware that we are at 6 o'clock, and to do the other stuff would take longer than we've got. So I'm actually going to arbitrarily suggest that we do a second one around the trade agreement part of things, if that's okay with people. I wanted to do the ISDS stuff first because that's where the real current risks lie. Yeah. And we have been, you know, some of the stuff I've been looking at is who owns the forestries. Yeah. So if we're looking at a result of the post-Gabrielle report about what needs to happen, and if some of that was implemented, what are some of the risks of an investment dispute occurring? And the problem is that MFAT would be giving the advice on that. And in all of the documents, even when we try to get them under the Official Information Act, that advice is redacted. So we can't actually see what advice is being given that may influence those decisions. So doing a few little videos and things around that might be quite helpful, maybe. Sorry, Mike.
Yeah, no, it would be. And we're currently embroiled in the ETS reforms, particularly in regard to the government's intention to remove carbon forestries, exotic forestries from the ETS. That's caused, as you probably be aware, an uproar amongst the carbon carpetbaggers. And they're all fighting for their lives. Well, not fighting for their lives. If they were fighting for their lives, they'd be leaning into it hard out. They're fighting for their bloody deaths, really, by supporting the, you know, that mechanism. So, yeah, it'd be really timely to hear a case study on that. It would have to happen soon though, because I think the recommendations are about to go out to the Crown, and submissions and stuff. But I'm sure that that's not a risk that people have factored in to date. I haven't heard any mention of it. But I'm also interested in what you consider to be where are the points of derailment for civil society? Where are the vulnerabilities and what what's the timing and we know that we've got leverage, but where are we going to use it? And so I'd be kind of keen to have a little discussion about that with whoever needs to be in that room.
What do others think?
I think it's a really good investment for Māori to team up with these corporations. They've just got the best law. You know what I mean? Like,
Yeah, that's so funny.
We just need to have 50% of their shareholdings and we're just a win-win. Anyway, it's just my thinking.
But that's only for us suing in another country.
No, we hop on either way, just a win-win. They're just so protected. Imagine if he whakaputanga and tiriti were amazing. Anyway.
But it's not a win-win, is it, for the environment?
No, but you're losing out. You might as well hedge your bets and team up with a corporation, it sounds like. I'm being a little bit facetious, but then again, putting my
Yeah, no, it's not silly, Billy Joe. I thought that to myself when I was, listening to Jane unpacking it. It was, so I remember back some years ago, this activist that I knew read out he disclosed who the author of the paper was, and everybody just fell back in absolute shock. And the fact that naturally their natural reaction was to endorse something as racist and as fascist as one of Hitler's and so it's the irony of what you are suggesting doesn't escape me. It's and I was thinking, gee, we should put this up in front of the iwi Cheese Forum and see if they'd go for it.
I'm going to put it forward,
Anyway.
I know it's bad.
One of the alternative things that, for example, Mona Jackson was involved with was setting up tribunals that do similar things, that are people's tribunals or Indigenous people's tribunals that put the corporations on trial. Of course, don't have the teeth of being able to have an enforceable damages award, but that's another kind of counter strategy, and bringing in Indigenous peoples from various other countries, various other territories and nations to conduct that kind of inquiry, and to maybe iwi Chairs would fund that.
Yeah, like a World Indigenous Forum. Well, no, but we need a bit more bite.
India?
Yeah, I was just thinking we did one actually in Paris at the People's Climate Talks when the Paris Agreement was being negotiated back in 2015 of ExxonMobil. And that was really cool and really powerful because, we were lucky enough to have Indigenous peoples from all over the world gathering. And I think those kind of like, not tongue-in-cheek, but like, fine, like we'll do it for you kind of things, works really well as a way of, I guess, like symbolic power. And I mean, it's interesting because when I talked about investor state dispute settlements at a trade gathering we had. Was it last month or the month before, Jane? I can't remember now. But one of the people from MFAT came up to me afterwards and said, "Oh, don't worry, like, we're not doing those anymore, da da da." I was like, "Yeah, but they still exist, so like we have a problem." So it's on their radar as something that I think civil society is like justifiably upset at, and they're trying to manage it. Manage the upset was my experience with that MFAT person. Yeah.
And of course, we don't know what will happen with the change of government. So there was a very similar, I mean, most of you are too young to remember, but in the previous incarnation of ACT governments, they had something called a regulatory responsibility bill, which almost got adopted and which had similar mechanisms in it. And before that, there was a very successful campaign against something called the Multilateral Agreement on Investment, or the MAI, which involved Māori marching from Te Hapua down over the harbour bridge and beyond, and that was defeated internationally. So there's actually quite a history of Māori resistance to these processes and to looking for alternative forms of accountability.
Jane, before you, sorry,
Tanya, yes.
Just quickly before you close today, you mentioned the idea of putting together videos and to sort of lobby and generate awareness, and you mentioned the Waiaku catchment and the inquiry and the report that came out of that on the management of slash and climate extreme weather events in the Ngāti Porou area. Well, Tui Wāmanhaven, who I mentioned, is the chair for Greenpeace in one of our Ngāti Porou hapu-based Te Ue Pohatu clients. She was one of those who called for the inquiry, and I'm sure I'm extremely keen to do one of those videos, maybe in collaboration with you, to demonstrate this, maybe as part of our WTO presentation, even though whether it's part of yours or mine, her story and the Ngāti Porou slash story is what keeps springing to mind for me for the interface between climate change and those acute impacts that we're facing at the coalface and industry as Māori. So just wanted to raise that with you before you close, so we can definitely follow up.
Kia ora, Tanya. That is actually a part of the second part of the presentation, because in all of these agreements now we're having chapters on sustainable forestry and so on, which doesn't deal with any of this, and we're having climate provisions that don't deal with them either. So maybe when we do the next webinar, we can look at that, and Ben can be in touch with you, because Ben is project managing all of this as to whether we can pull something together to take over there, and it would be very powerful if you were able to use it in your presentation.
Sounds really good. Thank
you. Okay, now I'm really aware that we didn't start with a karakia, but we should probably do the proper thing and finish with one. Would someone like to do so?
Okay, I'll put my hand up. So nō reira ngā mihi ki a koutou ngā tālinga Māori. Kei konei kei wanganui a mātou I tēnei kaupapa kōrero, tēnā koutou. O te rā, he karakia whakamatunga, he poto te kōrero, nunui te whakaaro. Nō reira, tai ao tū, tai ao rongo. Tai ao tangata ki te whai ao, ki te ao marama, te hei mauri ora. Yora.
Thank you for everyone for hanging in there. We will put this up on the website, and so if there are others who you think might want to have a look at it, please share it with them, and we'll sort out another time of the next few days to do part 2.
Well,
And
thanks, Jane.
thank you, Jane, for your tireless advocacy, and for protecting our collective interests when it comes to the scourges of the capitalist death machine, which we all know is, climate change is the end result of the extractive industries being able to rape and pillage not only the lands of Indigenous peoples, but also their populations in terms of the forced labor and slavery that set up the initial dynasties back in the days. And so this is the end game of all of that. What we're seeing is the unraveling of our natural world. We've seen that in our country just in the last few months. It's now killing women, children, elders, and fundamentally destroying and unraveling the fabric of our world. And so I can't think of any greater purpose than to throw up a challenge in the face of all of this. So congratulations, Jane. You've dedicated your life to this, and that doesn't go unnoticed amongst those of us who know of you and your reputation. So big mahis to you, Jane.
Kia ora. Kia ora. Well, we're all in this together.
Yeah.
Ka kite.
Ka kite.
Haere.